Let's come back from the break, please. Ms. Katz, will you join us on screen? There you are. So are we going from here to the stakeholder outreach?
Yes, that's correct. So the department calls Elizabeth Bisbee Keene.
Okay. Ideally, she can join us on screen.
Is she a panelist? Has she been admitted as a panelist?
She should be, although, you know what, she might have, yeah, okay, sorry. Let me re-add her. I had added her earlier, but I need to add her again. Hold on. I don't see her among the attendees either. Let's see here.
Hang on one second. She says she's on there.
If she's on under a different name, I just need the name. Oh, Liz Keene. Haha.
Sorry. Yeah, I was just asking her if she was Liz or Elizabeth on there.
Sorry. Yeah, I was looking under E. There she is. Oh, Ms. Keene, would you please spell your last name? Elizabeth is the standard spelling.
It is. Thank you, Madam Hearing Officer. My last name is Kuehn, Kuehn.
All right. Would you raise your right hand? Do you swear or affirm to tell the truth?
I do.
Thank you very much. Go ahead, Ms. Katz.
Thank you. Oops, sorry, I have the wrong questions up here. One second. All right. Ms. Keene, can you tell the board where you're employed?
I'm employed with the New Mexico Environment Department Air Quality Bureau.
And how long have you worked for the department?
Approximately 16 years.
And what is your current job title?
I am the Bureau Chief of the Air Quality Bureau.
And can you describe your job duties?
I manage the section chiefs who oversee the Bureau's 4 sections: planning, permitting, compliance and enforcement, and operations. I direct the overall management of the Bureau, including technical and administrative staff, air quality related planning and policy, operational permitting and compliance and enforcement services, financial oversight of the Bureau's federal grant and state matching funds, and other support services.
And can you please describe your educational and professional qualifications?
I have a Bachelor of Sciences in Environmental Studies from the University of Iowa. I've worked at the Air Quality Bureau for approximately 16 years, and my positions have included permit specialist, minor source manager, major source permit writer, and bureau chief.
And a copy of your resume has been provided as NMED Exhibit 5.
Yes.
And have you submitted pre-filed direct testimony on this topic in this proceeding?
Yes,
And your full written direct testimony on the stakeholder outreach for proposed Part 50 is marked as NMED Exhibit 6, correct?
yes, correct.
Do you have any changes to that written testimony?
No,
And do you adopt your written testimony here today?
yes.
And can you please summarize for the board the department's public outreach and stakeholder engagement on the draft rule?
I will, and I will share a demonstrative exhibit to walk us through those. And it looks like I need a permission to share. Oh, it's the share. Okay, so I don't need special permission. The share button is ready for me. As Ms. Katz mentioned earlier today, our Governor, Michelle Lujan Grisham, issued Executive Order 2019-003, directing us and our sister agency, the New Mexico Environment Department, and our sister agency, the Energy, Minerals, and Natural Resources Department, to develop a statewide enforceable regulatory framework to secure reductions in the oil and gas sector methane emissions and to prevent waste. At the time that that executive order was issued, the board did not have the authority under the Air Quality Control Act to pass regulations for methane that were more stringent than federal regulations, but it did have authority to pass more stringent regulations for VOCs and NOx for the purposes of reducing ambient ozone concentrations. And because ozone is emitted, or because the ozone precursor VOC is emitted along with methane and oil and gas operations, requirements that reduce VOC emissions necessarily reduce emissions of methane. New Mexico Environment Department held numerous public engagement sessions after the issuance of the executive order with their sister agency around the state to provide initial public outreach on the plan that was being developed. And on the slide here, you'll note the bottom half of this presentation outlines the dates and the locations of those 5 initial public stakeholder meetings that were held. Following the initial public outreach meetings in the summer of 2019, community members expressed a strong interest in holding a community impacts meeting to discuss the health, cultural, and economic impacts of the oil and gas industry, and NMED hosted, and with MNERD, a community impacts meeting as well on March 19th, 2020. In addition, both agencies convened the Methane Advisory Panel, which brought several technical stakeholders together to identify processes and equipment used in oil and gas sector, to develop emission and waste-based standards for those processes, and to propose standards, including monitoring, record keeping, and reporting for those standards. The MAP process yielded a technical background document identifying specific oil and gas equipment and processes for consideration and moving forward with that enforceable regulatory strategy. The MAP was comprised of 27 individual members representing environmental organizations, the nation, tribes, and pueblos, oil and gas industry, including small and large independent operators, as well as non-independent companies. Industry representatives included companies from both the Permian and the San Juan basins. And additional technical expertise was provided by professionals from Los Alamos National Labs, Colorado State University, and New Mexico Institute of Mining and Technology. The MAP process, as I indicated before, culminated with a draft technical report, which provided an informational foundation on the technical side of the ways in which the oil and gas sector emits methane, and therefore VOC under our statute, and what methods could be used to curb those emissions and prevent waste. The draft MAP technical report was issued on December 19th, 2019 for public comment, and approximately 42 comments were received on that report. In addition to this effort, the New Mexico Environment Department also undertook an extensive public outreach campaign related to its Ozone Attainment Initiative, which is the state program developed by the department, and which our expert Mike Backel will speak to later on. The New Mexico Environment Department held numerous public meetings related to the Ozone Attainment Initiative, and those dates and locations of those public meetings are listed on this slide. Over the last 2 years, during the development of the rule, we have promised to continue to seek comment and feedback from the public and the regulated entities and other stakeholders. As part of that effort, the department conducted extensive pre-petition outreach on the proposed rule, including a pre-petition full draft rule that was issued for stakeholder and public input on July 20th, 2020, for essentially a 45-day public comment period. We received extensive public comments on that pre-petition draft, which are posted on the website. And based on the comments received on that draft, the department made substantial revisions to the proposed rule that are reflected in the version included as part of the department's petition for regulatory change filed with the board on May 6th, 2021.
And Ms. Keene, can you just briefly talk about the engagement with the parties following the filing of the petition and the just overview of just changes that were made based on that process?
Sure. We have engaged in multiple party communications, extensive communications since the draft was issued, made significant edits and revisions to the proposed rule in response to those comments. We have met with each stakeholder, as Ms. Katz mentioned before. We have accommodated each meeting request that we have received, and we have made edits to the rule up until the filing of the September 16th version.
Thank you, Ms. Keene. I have no further questions for Ms. Keene on this topic.
All right, thank you very much, Ms. Katz. We'll turn now to questioning. Ms. Fox, do you have questions of Ms. Keene?
None, Madam Hearing Officer. Thank you.
Thank you. Ms. Caraños?
No questions, Madam Hearing Officer.
All right. Professor Pasiniak?
No questions, Madam Hearing Officer.
All right. Ms. DeVore?
Questions, thank you.
I'm sorry? Mr. Buck?
No questions, thank you.
Oh, okay, thank you. Mr. Nykiel?
No questions, thank you.
Thank you. Mr. DeSalen?
No questions, thank you.
Thank you. Mr. Heiser?
No questions, thank you.
Thank you. Mr. Rose?
No questions.
All right. Mr. Jano?
No questions, thank you.
Okay. Mr. Boutier?
No questions.
Ms. Gutierrez?
No questions, thank you.
Mr. Newman?
No questions, thank you.
All right. And Ms. Witherspoon?
No questions, thank you.
All right. Thank you. I'm going to turn to the board members now to see if they have questions of Ms. Keene. While I'm doing that, in the event you are not a panelist and you have a question for Ms. Keene, please reach out through the chat. Madam Chair, do you have a question of Ms. Keene?
Madam Hearing Officer, I don't have any questions. Thank you.
Vice Chair Trujillo Davis?
I don't have any questions. Thank you, Madam Hearing Officer.
Thank you. Member Cates?
No questions, thank you.
All right. Member Bitzer?
One question. And thank you, by the way, for what has to have been an interesting year of extra duty here, getting to this point. Has there been any complaint from anybody, any quarter, any stakeholders, anybody in the community that they didn't get adequate notice or proper procedural due process to this point?
Member Bitzer, not that I am aware of.
All right. Member Garcia. Member Garcia, were you speaking? No questions. All right. Member Honker.
No questions, thanks.
All right, thank you. Thank you so much, Ms. Keene. Is there any reason not to excuse Ms. Keene? Nope, I see no questions in the chat. So thank you very much, Ms. Keene, you're excused.
Thank you.
So Ms. Katz, where are we going from here?
Madam Hearing Officer, I mean, we could go to topic number 7 on the spreadsheet that I did send to Ms. Jones, and I believe she sent it to the board members. And so that will be the Ozone Attainment Initiative and the Ozone Path Forward Plan, and that will be Department Witness Michael Baca, and Mr. Knight is going to put on Mr. Baca.
Terrific. Let me look among the attendees for Mr. Baca. And, oh, there you are right there. And Mr. Knight, if you would join us on screen. Oh, there you are. Terrific. We have Mr. Baca and Mr. Knight. Mr. Baca, and the standard spelling, Teresa. If you would please raise your right hand. Do you swear or affirm that you will tell the truth?
I do.
Thank you very much. Mr. Knight, whenever you're ready.
Thank you, Madam Hearing Officer. And Madam Chair, members of the board, good afternoon. Mr. Baca, could you tell us where you are employed?
Yes, Madam Chair, members of the board, and Madam Hearing Officer. I'm employed with the New Mexico Environment Department Air Quality Bureau.
And how long have you worked for NMED?
Approximately 17 years.
And what is your current job title?
Control Strategies Manager.
What are your job duties?
I manage the Bureau's Control Strategies Unit, overseeing a staff of 6 that are responsible for the development and of air quality plans and regulations, including the State Implementation Plan, or SIP, for the state of New Mexico. This unit also participates in regional air quality improvement groups and oversees mitigation projects, air quality grants, and air quality studies, especially as they pertain to achieving and maintaining the national ambient air quality standards.
Thank you. Could you please describe your educational and professional qualifications?
Sure. I hold a Bachelor of Arts in Chemistry from Carleton College, and I have worked for the Air Quality Bureau for over 13 years. My positions have included staff manager and environmental analyst advanced in the Control Strategies Unit of the Planning section.
And a copy of your resume has been provided as NMED Exhibit 2?
Yes.
And have you submitted written direct testimony in this proceeding?
Yes.
And is your full written direct testimony, does that appear as NMED Exhibit 1 and your full written rebuttal testimony appears as NMED Rebuttal Exhibit 22.
Yes.
Do you have any changes to your written testimony?
No.
And do you adopt that written testimony here today?
Yes, I do.
Okay, I'm going to walk you through your direct testimony and rebuttal testimony and have you summarize that testimony on the various topics that you covered, all right?
Mr. Knight, I'm sorry, Mr. Baca is very quiet for some of us. That's an issue for others. So Mike, if you could maybe move closer, speak a little louder.
Thank you. All right. Can you summarize the Clean Air Act regulatory framework for ozone?
Sure. The Clean Air Act requires the EPA to set National Ambient Air Quality Standards, or NAAQS, for air pollutants that are determined by EPA to be harmful to the public health and environment. EPA has set NAAQS for 6 principal pollutants called criteria pollutants. The 6 criteria pollutants are ozone, carbon monoxide, nitrogen dioxide, sulfur dioxide, lead, and particulate matter 10 microns or smaller and 2.5 microns smaller or less. So that's PM10 and PM2.5.
Mr.
The current
Baca,
ozone
sorry.
NAAQS, or the 2015 NAAQS,
Mr.
is
Baca?
70 parts per billion.
Mr. Baca, I'm sorry to interrupt you. You are still too quiet. Can you sit closer to the microphone, maybe?
I'm using earbuds, so let me see if I can adjust some settings on my microphone. Okay, is that any better?
A tiny bit better, but not enough better.
If I turn him up on my end, Mr. Knight is screaming, so I need Mr. Baca to speak much louder, please.
Thank you, Mr. Bois. Mr. Baca, can you raise the volume any more?
Yes, does that sound any better?
Oh, that's fantastic. Yeah.
Okay, let me take these earbuds out and speak to you this way through my microphone computer.
Thank you.
Sorry about that.
Mr. Baca, I think, well, maybe we should ask the court reporter how far back. Should we oh, she's good. Okay. Okay, so you had just mentioned that what the 6 criteria pollutants were. Could you talk about the current ozone National Ambient Air Quality Standard?
Sure. So the current NAAQS is set at 70 parts per billion, and this standard was set in 2015. When they revised the previous standard, or the 2008 standard, from 75 parts per billion down to 70 parts per billion.
Thank you. These are health-based standards, correct?
That is correct. As I discussed in my pre-filed testimony, the primary NAAQS are health-based standards and are set at levels meant to protect the public that are most at risk from being harmed from ozone in the ambient air. And this includes asthmatics, children, older adults, and people who are active outdoors, such as construction workers and others that work outdoors. So children are at the greatest risk from ozone exposure because their lungs are still developing and they are more likely to be active outdoors when ozone levels are high, so which increases their ozone exposure. Health problems caused by ozone include coughing, sore throat, difficulty breathing, inflammation, and damage to airways, increased frequency of asthma attacks, and aggravation of lung diseases such as asthma, emphysema, and chronic bronchitis. EPA also sets secondary NAAQS to protect public welfare, including protection against decreased visibility and damage to animals, crops, vegetation, and buildings. The secondary standard is identical to the primary standard in averaging time, level, and form of the 2015 Ozone NAAQS. The Clean Air Act under Section 108 requires EPA to reevaluate the NAAQS on a periodic basis, which may result in the standards being revised based on health and environmental criteria set by EPA.
So what process is triggered when the National Ambient Air Quality Standard for a particular pollutant is revised?
The establishment or revision of a NAAQS triggers a review of all areas throughout the country to determine if pollutant concentrations are below or above the new standards. The culmination of the process results in EPA promulgating designations for all areas as in attainment of the standard or non-attainment of the standard for each pollutant. So this process requires EPA to collaborate with states and tribes and takes into consideration air quality data, emissions and emissions-related data, meteorology, geography and topography, and jurisdictional boundaries. If the air quality in a geographic region meets or is below the standard, it is designated as an attainment area. If the region is above the standard, it is designated as a non-attainment area. And for areas that do not have monitoring or when modeling is not an appropriate tool for designations, EPA designates areas as unclassifiable or attainment unclassifiable. EPA is required to make these designations within 2 years of promulgating a new or revised NAAQS, with a 1-year extension when insufficient information exists to promulgate such a designation. So as discussed in the testimony of Mr. Ayer, the determination whether concentrations of a criteria pollutant in an area are meeting or exceeding the NAAQS is based on the design value for that pollutant. For ozone, the design value is determined by calculating the 3-year average of the annual 4th highest daily maximum 8-hour average ozone concentration.
All right. So what is the current designation of the areas where the sources at issue in this proposed rule are located?
Most of the areas are designated as attainment areas. There is one ozone non-attainment area in the state, and that is in Doña Ana County near Sunland Park, New Mexico. That's on the outskirts of El Paso, Texas.
Thank you. Can the board or the department designate ozone non-attainment areas?
No, neither the Clean Air Act nor the Air Quality Control Act give the board or the department the authority to designate an area as non-attainment. It is solely within the EPA's authority to designate attainment and non-attainment areas.
Okay. Who decides to designate or redesignate an area under an existing national ambient air quality standard?
Under the Clean Air Act, EPA is responsible for designating and redesignating areas excuse me, within a state with respect to the criteria air pollutants. EPA may at any time notify the governor of any state that available information indicates that the designation of an area or portion of an area within a state should be revised. Likewise, the governor of any state may, on their own motion, request a redesignation of any area within the state. The decision to redesignate is based on air quality data, planning and control considerations, or any other air quality related considerations that EPA deems appropriate.
In making that decision, can EPA consider measures being implemented by a state to address monitored exceedances?
Yes. Under the EPA's Ozone Advanced Guidance, when an area that is designated attainment has monitors showing violations of an existing NAAQS, EPA can consider measures being implemented by the state to address those monitored exceedances when determining whether or not the area should be designated non-attainment. And emissions reductions that are achieved through the Ozone Advanced program could be credited in any future non-attainment SIPs developed under Part D of the Clean Air Act.
Does the Air Quality Control Act define non-attainment area?
Yes, it does. That definition is at section 74-2-2N of the Air Quality Control Act, and it is the same as the current definition in the Clean Air Act.
Okay, how does the Air Quality Control Act direct the board to act with respect to an area with elevated ozone?
So section 74-2-5 of the Air Quality Control Act, or AQCA, mandates that the board take action to control VOC and NOx emissions when the board determines, and this is quotes, determines that emissions from sources within its jurisdiction cause or contribute to ozone concentrations in excess of 95% of the primary ozone NAAQS. So under the statutory provision, the board is required to adopt a plan, including rules to control emissions of NOx and VOC to provide for the attainment and maintenance of the standard.
And what is the department doing to assist the board in carrying out this duty under the Air Quality Control Act?
So NMED has undertaken the Ozone Advance Initiative, the Ozone Attainment Initiative, or the OAI, to propose the plan as well as regulations required by the statute.
And can you discuss what the department's Ozone Attainment Initiative entails?
Sure. There are currently 9 counties under the board's jurisdiction that have or are adjacent to monitoring sites registering ozone concentrations in excess of 95% of the standard. To address this issue, and as required by law, the department has undertaken its Ozone Attainment Initiative to develop a plan and a series of rules to bring before the board, as well as other voluntary measures to mitigate emissions of NOx and VOC from all contributing sources. The OAI is the plan the state is following in order to meet the statutory requirements of the Air Quality Control Act. So under the umbrella of the OAI, the department is also participating in EPA's Ozone Advance program to promote proactive and early actions in designated attainment areas to reduce ozone for the continued maintenance of the standard. The department developed a draft Ozone Advance Path Forward as part of the program, which is included as NMED Exhibit 4 to demonstrate to EPA how the state's plans to address high ozone concentrations before EPA promulgates a non-attainment designation for any of the counties. Since the Air Quality Control Act does not prescribe what the plan should contain, the department followed EPA guidelines to develop the Ozone Advance Path Forward. This plan is sufficient to satisfy the requirements of the Air Quality Control Act, and the department is proposing that the board adopt the Ozone Advance Path Forward to comply with the board's statutory duties. A fundamental aspect of the OAI is determining what sources are contributing to ozone concentrations. To this end, the department contracted with Western States Air Resource Council and Ramboll to conduct photochemical grid modeling for ozone to determine which sectors within the board's regulatory jurisdiction are contributing to ozone concentrations and to support the rulemaking efforts. The results of this modeling are presented in Ralph Morris's testimony at NMED Exhibit 106. The Air Quality Control Act also requires the board to adopt regulations as part of its plan to address these rising ozone concentrations. So the proposed Part 50 is the first set of rules that the department is bringing before the board. These will be followed by regulations to control emissions from on-road mobile sources, which the department will bring before the board later this year. These regulations will set standards for low-emission vehicles, or LEV vehicles, and zero-emission vehicles, or ZEV, that will provide further mitigation of ozone precursors.
Okay, thank you for that. Is it possible that even with all the regulatory efforts of the OAI, some areas may not be able to reach or stay in attainment of the ozone NAAQS?
Yes, that's definitely a possibility, especially with EPA currently reviewing the 2020 decision to retain the ozone NAAQS as is. The Biden administration, if they lower the standard or these areas of New Mexico do not attain the standard in a timely fashion, the regulatory path forward could be a formal non-attainment designation by EPA. So the intent behind the board's mandatory duties outlined in the Air Quality Control Act is to take actions to avoid a non-attainment designation and the planning, regulatory, and financial burdens of implementing a non-attainment designation. Generally, the Clean Air Act outlines a non-attainment process that will last a minimum of 25 years. So that gives 5 years for designations and attainment of the standard, and 2 10-year maintenance periods before an area can be redesignated as attainment. So if an area fails to attain the standard by its attainment date, it is reclassified into a more stringent classification to include additional planning requirements that progressively become more stringent with every reclassification. So this prolongs an area's attainment date to allow for the implementation of additional control strategies. So the non-attainment process triggers planning and permitting requirements, including emissions inventories, transportation conformity, reasonable further progress, permitting offsets, and lowest achievable emission rate for equipment. All of these are time-consuming and costly to both the industry and the department, and cause a competitive disadvantage to New Mexico businesses and communities.
So is it likely that even if the proposed rule is adopted, some areas of the state would still go into non-attainment status?
Well, the department acknowledges that the modeling indicates that the reduction in ozone concentrations achieved by the proposed rule would not be sufficient to bring some of the areas into compliance with the standard. However, incremental reductions can keep an area from receiving a higher classification in the future and avoid the more rigorous and costly requirements for such a classification.
Okay, thank you, Mr. Baca. Madam Hearing Officer, those are all the questions I have for this witness at this time. Mr. Baca will come back for rebuttal testimony following the other parties on this topic.
Thank you very much, Mr. Knight. Ms. Fox?
And Madam Hearing Officer,
Yes.
I would like to also note that we have an amended Exhibit 4, which we have sent out earlier today to all of the other parties. And I don't know, perhaps it might be premature to see if anyone has an objection to it or not, but I just wanted to note that we are going to ask that amended Exhibit 4 be made part of the record, subject to any objections and your ruling on those objections.
Okay, I believe it might have just been sent, and so I'm not sure the other parties have had a chance to review it. So maybe we'll take that up a little later.
Yeah, I think that's fine.
Okay.
Madam Hearing Officer, if you would, the amended Exhibit 4 doesn't appear as though it identifies the changes from the previously filed Exhibit 4. I was wondering if the department either could explain it or has something that identifies the changes that they made. It's not suggesting it's going to be objectionable, and probably won't, but I can't tell based on the submittal exactly what was changed.
All right, thank you, Mr. Rose.
Yeah, and Mr. Baca is going to be testifying about those changes in his rebuttal. We could identify them, though. Maybe, Mike, can you maybe point to where they are in the document?
The changes were made in response to rebuttal testimony provided by NMOGA and IPA-NMA, IPA-A&M. And so the main changes were to the description of the photochemical modeling. That's that one section. There was changes made to that, and that was it.
Do you have a page number, or I don't know if, Lou, do you need a page number?
I think I can find it, but it isn't, even as those changes, it'd be helpful, and not suggesting you're required to do it, but if you had a red line version, it would certainly be a lot easier to determine whether there's a problem with any of that. And since Mr. Baca is going to testify on rebuttal after everyone else, if we're going to address the amended exhibit, we'll need to know what the changes are.
Sure, I can work on making a red line and sending that around.
That would be helpful. Thank you.
Thank you, Mr. Rose and Ms. Katz. So the time is now to ask questions of Mr. Baca. I'll start with the parties. Ms. Fox, do you have questions of Mr. Baca?
None, Madam Hearing Officer, thank you.
Thank you. Ms. Paranos? She may be muted again. Professor Pisiniak?
No questions at this time, Madam Hearing Officer.
Thank you. Ms. DeVore? May have stepped away. Mr. Nykiel?
No questions at this time. Thank you.
All right, and I have a text from Ms. Paranos saying she has no questions. Mr. DeSalen?
No questions, thank you.
Thank you. Mr. Heiser?
No questions, thank you.
All right, Mr. Rose?
Yes, Madam Hearing Officer, I have a few questions of this witness.
All right, go ahead.
Okay. Mr. Baca, are you familiar with the state's current implementation plan provisions as they relate to ozone?
Yes, I am.
And did you review those in developing the path forward and the ozone initiative?
Not as part of this, no.
How does this plan differ from what's currently in the implementation plan?
Okay, this plan is in response to Ozone Advance. So this is not a plan that's developed as required by the Clean Air Act. The provision that you're talking about, it sounds like a SIP requirement.
Correct, under section 110. And are you familiar with what would be required in terms of a plan where an area designated non-attainment by EPA?
Yes, I am.
And would the path forward or the ozone initiative satisfy the requirements of EPA if the areas were designated non-attainment?
As stated earlier, the Ozone Advance Path Forward is not to address any requirement of the Clean Air Act.
In terms of looking at the path forward, it appears as though the department made a decision on whether or not to regulate oil and gas first and then transportation-related pollutants second. Is there any explanation in this document about how those priorities were set and why the department decided to regulate oil and gas first?
Can you maybe repeat that question so I can try to
Sure.
gather that all together?
No, that's fine. And if you need clarification, just ask. You testified in terms of the department's decision that it was regulating oil and gas. This proposal was the first, and that the department intended to propose transportation-related requirements for mobile sources or cars and trucks later. I was wondering whether or not the document, which is Exhibit 4, explains how the department made the decision to regulate oil and gas first, transportation-related pollutants second, and then any other controls after that.
So I guess we can discuss a little bit about how the department arrived at regulating oil and gas first. Is that the main question?
And I was wondering excuse me for interrupting, whether Exhibit 4 explains that or if it's in some other exhibit that the department or testimony the department submitted.
That would probably be under another exhibit. The Ozone Advanced Path Forward is not intended to justify the rulemaking or justify any of the source sectors included in the rulemaking. The Ozone Advanced Path Forward is intended to satisfy the requirements of the EPA program.
Thank you.
It's an explanatory document.
Okay, thank you, Mr. Baca. I think you also in the document discuss NOx emissions reductions, and I was curious as to whether or not when you did that, whether you included potential reductions that would be necessitated by the regional haze program, whether or not any of those anticipated reductions were factored into any of the decision making here.
Well, unlike this matter, regional haze is required under the Clean Air Act. So any emissions reductions we do under regional haze have to be federally enforceable, which what we are not doing here today. We are not adopting this as a SIP rule today.
And
so any emissions that we do achieve through regional haze would be through that Clean Air Act program.
And were those factored into any of the analysis here in terms of what the regulatory program that you're proposing looks like?
I'm not sure I understand what you're asking as pertains to regional. So the regional program is focused. We're only looking at certain sources for control. So it's a whole different scope.
And are you aware of, I take it the department has not yet proposed to the board its regional haze proposal, and that would have to go before the board before it was submitted to EPA, is that correct?
That is correct.
And as you currently understand it, is the department intending to regulate certain oil and gas sources as part of the regional haze program as well?
The department has not made a determination on that as of this time.
I take it though that in terms of the facilities or the sources for which the department required a 4-factor analysis, those did include certain oil and gas sources, particularly in the southeast, correct?
That is correct. So we screened about 23 sources under NMED's jurisdiction, and I believe 20 of those sources were oil and gas sources. So those represented the Title V sources that we screened, which are the largest sources in the state.
Thank you, Mr. Bach. I have no further questions.
Thank you, Mr. Rose. Mr. Jano?
No questions.
Thank you. Mr. Boutier?
No questions.
Thank you. Ms. Gutierrez?
No questions.
All right. Mr. Newman?
No questions. Thank you.
All right. Thank you. And Ms. Witherspoon? She may have stepped away. Mr. Knight, do you, oh, I'm sorry. I'm going to turn to the board members now. And while I am doing that, if you are not a panelist and you have a question of this witness, please reach out in the chat. Madam Chair, do you have questions of Mr. Baca?
Madam Hearing Officer, I don't have any questions at this time. Thank you.
Thank you. Vice Chair Trujillo Davis.
I don't have any questions at this time. Thank you.
Okay, thank you. Member Cates?
No questions.
Thank you. Member Bitzer?
No questions.
Okay, thank you. Member Garcia? No, I see her shaking her head no. Member Hunker?
No questions.
All right, thank you. I see no one reaching out through the chat. Mr. Knight, did any of Mr. Rose's questioning raise in you a need to redirect Mr. Baca?
Yes, Madam Hearing Officer. I just have a few redirect questions. Mr. Baca, Did Dr. Rasso testify this morning that the oil and gas sector is the largest anthropogenic source of VOCs in New Mexico?
Yes, she did. Yes, he did. That is correct.
Okay. And does the department have the resources to adopt multiple regulations under the OAI simultaneously?
No, we do not. So we had to prioritize which sectors we are looking at based on which ones are the most impactful.
And is the department currently working on the developing the clean cars rules for the transportation sector right now and preparing to petition the board within the next few months?
That is correct. The department is currently undergoing early stakeholder engagement. I believe they have held at least one meeting and another one happening shortly, if not already. I do believe the plan is to propose their rule to the board for a hearing in May.
Okay, thank you very much. Okay, that's all the redirect questions I have, Madam Hearing Officer.
All right, thank you very much. I had one question in the chat asking for a repetition of Mr. Baca's job title, and so I'll just offer it. He testified he was the Control Strategies Manager for the Air Quality Bureau of the Environment Department. Is there any reason not to excuse Mr. Baca?
No, he may be excused.
Thank you so much for your testimony, Mr. Baca. All right, where are we going from here, Mr. Knight?
Madam Hearing Officer, I will defer to my co-counsel, Ms. Katz.
All right.
So, Madam Hearing Officer, there were rebuttal witnesses on this topic. So I believe Mr. Namoga has Mr. Smitherman listed and IPA&M has Mr. Blewett. And so we would, I believe those witnesses would go up and then the department would do its rebuttal.
All right.
Madam, this is Eric Heiser for Namoga, and we're not going to call Mr. Smitherman for this issue.
All right. And is Mr. Smitherman with us? Shall I make him a panelist, or I might have already done that? Let's see here.
Madam Hearing Officer, we are not planning to ask Mr. Smitherman to say anything on this rebuttal issue.
Oh, I'm sorry.
I don't think he said anything in his rebuttal.
Oh, okay. I'm sorry. I didn't hear that correctly. All right. So we will not be hearing from Mr. Smitherman. Mr. Rose, will we be hearing from Mr. Blewett?
Madam Hearing Officer, I believe he's currently viewing this as a, but not a panelist, so you may have to admit him. He's available to testify this afternoon, and he has some other topics which he'll testify on later as well. Madam Hearing Officer, you're muted, so.
I was just talking to myself as I made Mr. Blewett a panelist.
Okay.
We should be able to bring him up on screen.
Hopefully.
Mr. Blewett, can you hear me?
I can hear you. Can you hear me?
Oh gosh, no, you sound like you're talking through a blanket.
I'm as close to my computer as I can get.
Is there a volume setting you might be able to control?
I'm at 100% volume.
Okay. Teresa, you're going to be able to turn this up?
I'm not hearing you very well right now.
I can turn it, Mr. Rose will need to speak a little lower.
Okay.
Or softer, hopefully.
Softer.
Yes. All right. Don't use your
Sure, I can go
voice,
lower.
Miss Rose. Okay. So, Mr. Blewett, if you would please spell your last name. Doug is the standard spelling.
Blewitt.
Thank you. And if you would raise your right hand, please. Do you swear or affirm to tell the truth?
I'm not, you're going to have to speak up.
Do you swear or affirm to tell the truth?
Yes.
All right. Thank you. Mr. Rose, if you would please.
Yes, Mr. Blewett, could you, you've already identified yourself. Could you explain your educational and work background?
Yes. I have a bachelor's degree in chemistry and physics. I've done graduate work at the University of Wisconsin and the University of Illinois Institute of Technology. I have over 45 years of air quality experience. I have been involved in development of accidental release models for dense gases that are specific to hydrogen fluoride. I've published numerous papers on modeling and monitoring and analysis of data. I was a Colorado Air Commissioner. I served as secretary for 6 years. I've been involved in numerous research programs regarding air quality issues in the West. I think that concludes.
Mr. Blewett, did you prepare written direct and rebuttal testimony for this proceeding?
Yes, I did.
With respect to the direct testimony, do you have any corrections or to that written testimony?
No corrections.
If you were asked those same questions that are in your written testimony, would your answers be the same here in person as they were in your written submittal?
Yes.
Madam Hearing Officer, I'd offer Mr. Blewett's testimony. Can't remember the exhibit number here, but as in this proceeding.
Okay, I will need an exhibit number. So let's take a moment to find that.
I'll have to track that down here in a minute. Got it somewhere.
Madam, can you share the screen so I can present slides?
Yes, I can. Just give me a sec.
Can you?
Hearing Officer, I don't seem to have the list here. I did expect to have Mr. Blewett testify this afternoon, so not quite as prepared as I might have been. We only have a handful of exhibits, so. And rather than try to delay this even further, I was hoping someone would have that list handier than I do. I have it, I just can't, can't immediately find it.
This is Stuart Boutier. This is Exhibit 12, I believe.
Yeah.
That's the direct testimony?
No, it's
I'm sorry, that's the rebuttal.
Right, we'll get to the rebuttal here in a sec.
I have too many boxes, Lou.
Well, it's okay. I have more binders than I care to look at here, but
So let's track down the right exhibit number so we can keep a clean record.
It's,
In the meantime,
Madam Hearing Officer, Mr. Bullett's direct is Exhibit 6.
Exhibit 6, and that was Mr. Heiser speaking. So thank you.
That is
very
correct.
much. Thank you.
I'm glad Mr. Heiser's more together than I am on this. So
Thank you. Thank you. All right. So the direct testimony is Exhibit 6. Were there any? I don't believe there were any objections to IPA and M Exhibit 6. So unless someone speaks up right now, it's admitted. All right.
Madam Hearing Officer, I'd note that Mr. Blewett's direct and rebuttal relate to topics beyond just this one. So I assume that when it's admitted here, I won't have to offer pieces later as to admission.
I agree with you.
Thank you, Madam. Thank you, Madam Hearing Officer. Mr. Blewett, did you prepare written rebuttal testimony in this proceeding? I think he's adjusting his headgear here.
Can you hear me now?
It's about the same.
Well, I can hear you much better.
Okay. Did you prepare written rebuttal testimony in this proceeding?
Lou, are we ready to start this?
Yes. Well, no, not the slides yet.
Okay.
I'm just talking about your rebuttal testimony. Did you prepare written rebuttal testimony in this proceeding?
Yes, I did.
And do you have any corrections to your written rebuttal testimony?
No, I do not.
And if I were to ask you the questions here that we asked in the written rebuttal, would your answers be the same as they were in your written testimony?
Yes.
Madam Hearing Officer, I would offer IPA&M, I guess it's Exhibit 12 in this proceeding, and ask it to be admitted.
All right. I don't remember any objections to IPA&M Exhibit 12. So unless someone speaks up right now, it is admitted. Thank you.
Mr. Blewett, could you briefly summarize your direct and rebuttal testimony? And Madam Hearing Officer, I believe he has a demonstrative exhibit which we circulated yesterday that he's going to use for his summary.
Can you see my slides on your screens?
No.
Not yet.
No.
How do I share my screen?
There's probably a share button.
Should be a button there that allows you to share.
There you go. There you go.
It's now starting.
Okay. Great.
You need to increase the size of that if you can. There we go. That's better.
Okay. Sorry for my technical ineptness. Let me start out by saying we're here to address ozone, and that's really what this is all about. And the board has taken a very interesting position, wanting to protect air quality, and I think it's, in some respect, it's a very good idea. That if concentrations get in excess of 95% of the NACs for ozone, that they need to develop a plan. And the purpose of this regulatory action is to protect New Mexico from new violations of the current NACs by sort of establishing a safety factor. And it basically establishes that NMED and the board need to establish a plan to reduce ozone concentrations. This is not a regulatory action about reducing methane. And the plan really must develop a control strategy. And control strategies are difficult, and they need to combine monitoring and modeling to try to draw out as much information as possible to ensure that the NAAQS is maintained. I think it's also important to use modeling to identify culpable sources of what sources contribute to monitors, and those potential contributions must address significant impacts. And significant is a word here that has some regulatory meaning. So we want to make sure that the reductions we're achieving are meaningful. And I think that's part of the whole process to identify how to achieve compliance. I think from my perspective, I'm not sure that the plan and the modeling that have been developed satisfy these requirements. We'll go to the next slide. I think one of the things that's really important in reviewing the modeling is a discussion of emission inventories. Emission inventories are one of the main inputs to models. And Rambo developed 3 emission inventories. A 2014 base case, which is based on the NEI inventory, and there were some adjustments made to that, which were appropriate. They also and the 2014 inventory was used basically to test the accuracy of the model. And I have no real objections to the model testing that was done. They also developed a 2028 future year base case. And this inventory is really important in this proceeding because it demonstrates very significant reductions in NOx and VOC emissions. But unfortunately, there's no documentation provided regarding what sources are included, calculation methods, future year assumptions, going from 2014 to 2028.
Madam Hearing Officer, I'm sorry to interrupt. I'm concerned that this is modeling testimony and not directed at Mr. Baca's. If that could be explained, because to me this seems to have to do with Mr. Morris's testimony.
It is.
Mr. Rose?
Madam.
No, let's, I'm going to call on Mr. Rose.
Okay.
Yes, Madam Hearing Officer, I believe what the witness is testifying to is the adequacies, or in his view, the inadequacies of the plan. And the plan, as it references the modeling and uses the modeling as a decisional tool in the plan, I believe is what he's addressing. Now, I can't remember if Mr. Blewett had other slides. Most of this will probably be addressed when the department's modeling witness testifies, I think tomorrow, as to the adequacy of the modeling itself. But as to the plan, I believe, Mr. Blewett, I thought you had other slides specifically addressed to the plan that we circulated yesterday, and this is really the modeling related.
Okay. Ms. Katz, has he drawn a distinction that's helpful here?
This looks like now we've got the right slide deck.
Thank you. Yes, I agree.
Okay.
Mr. Blewett, I think you're muted.
Yeah. Okay, go ahead.
I thought this was a modeling discussion, which is why I pulled up those slides. I'm sorry. The first slide we really talked about, which was the same in both of them. And I think the plan also needs to address the cost to control in terms of ambient impacts. And this directly relates back to modeling. So it's very hard to separate all of these issues. I think the procedural issues that we have, and this really goes to the other presentation, this future year base case, which is really crucial in the modeling and the impacts and the benefits, has no documentation whatsoever. There's some emission totals presented, but they're not, they're very vague, and we really can't address what's going on there. That 2028 emission inventory needs to talk about reductions from controls that will be implemented from recently promulgated sources. That's not discussed. Retired sources that have changed fuel type from oil to natural gas. That's retired sources are not discussed. Growth calculations. That's a very important issue for oil and gas because of the unique nature of oil and gas emissions, which I will talk about at another time in this. The calculation methodology that was used did not, in my opinion, although I can't confirm this, address the issue of decline from natural gas wells, which affects both long-term VOC and NOx emissions. Natural gas wells decline. The reason many new wells are being drilled is to offset the decline in production with new production. And these wells decline exponentially. And some emission sources, such as compressors, dehydration units, tank emissions, are directly related to production rate. There are some inconsistencies in VOC emissions presented in the Ramble technical support document that need to be resolved. And the 2028 emission inventory really needs stakeholder and public review. I think those are all important issues that really pertain to spending some more time looking at what's been done to make sure we actually achieve what we're looking for. If the 2028 future year base case were implemented, and we don't know what that is, how would NMED address enforceability? The last thing we want to do is have sources have emission limits that are state-only emission limits versus federally enforceable emission limits. And Mr. Bacchus sort of alluded to the fact that some of what we're talking about here might not be federally enforceable. And I think that's an important issue that has to be addressed. The modeling did not separate NOx and VOC emissions. And we have heard discussions about impacts from various oil and gas segments, but it's been combined. And we really don't know the relative importance of NOx or VOCs. Mr. Morris's testimony that will be given tomorrow, he indicated there were only a few grid cells, areas where concentrations were computed.
Objection. I'm sorry, Mr. Morris is not testifying, and so it's inappropriate to be addressing his testimony here.
I thought we had drawn that distinction, Mr. Rose.
Madam Hearing Officer, relates to the adequacy of the plan. And that's what I thought Mr. Baca's testimony was related to, that the modeling deficiencies and some of the information that Mr. Blewett is identifying were not included in and not part of the plan, and therefore the plan itself was insufficient, in addition to the modeling having problems.
Okay, and again, to the extent that he's expressly referring testimony we haven't heard yet, I don't know that he's walking on the right side of that line. And I understand they're all interconnected, but we're now down to his last 7 minutes of testimony, so I'm hoping he can get back to rebutting Mr. Baca's testimony.
Let me restate that NMED needs to carefully review ozone formation of NOx versus VOCs. And what was done in the modeling combined both NOx and VOCs together, and it is not possible to separate that. I think an iterative process needs to be established to resolve all of the identified technical issues that I've pointed out here. And that concludes my remarks.
Thank you.
Thank you, Mr. Blewett. I have no further questions of this witness.
All right, thank you, Mr. Rose. Ms. Katz, do you have questions of Mr. Blewett at this time?
No, I do not, and neither does Mr. Knight. He will be doing the SIR rebuttal.
Oh, okay, thank you. Ms. Fox?
None, Madam Hearing Officer. Thank you.
Thank you. Ms. Paranos?
No questions, Madam Hearing Officer.
Thank you. Professor Persiniak?
No questions right now, Madam Hearing Officer.
Thank you. Ms. DeVore? She may have stepped away.
Thank you.
Oh, okay, thank you. Mr. Nykiel?
No questions, Madam Hearing Officer.
All right, Mr. DeSalen?
No questions, thank you.
Thank you. Mr. Heiser?
No questions, Madam Hearing Officer.
Thank you. Mr. Jano?
No questions, Madam Hearing Officer.
Thank you. Mr. Boutier?
No questions.
Thank you. Ms. Gutierrez?
No questions, thank you.
Thank you. Mr. Newman?
No questions, thank you.
Thank you. And Ms. Witherspoon?
No questions.
Thank you. I'm going to turn now to see if the board has any questions. While I'm doing that, in the event you are not a panelist and you have a question for Mr. Blewett, please reach out in the chat. Madam Chair, do you have a question of Mr. Blewett?
No questions for me, Madam Hearing Officer. Thank you.
Thank you. Vice Chair Trujillo Davis?
Yes, I have a couple of questions. Thank you, Madam Hearing Officer. My questions actually, I had a very difficult time hearing the full testimony. So I just want to clarify, is the basis of your testimony that the 2028 projections are too conservative in their calculation because they failed to account for well decline and recently promulgated rules?
Let me answer that in several parts. I believe that the emissions in the 2028 inventory may not be accurate. There may be inflating NOx emissions and VOC emissions. I have reviewed the Mancos EIS emission inventories, and I saw that was the case in those inventories, and that this emission inventory was developed directly from the Mancos, I believe. If emissions are overstated, that means air quality will actually be better. And also, it will affect the cost to control calculations because you won't see as much of a reduction. The good news is that the modeling shows very dramatic reductions in ozone from the 2028 case. So it's kind of an interesting situation. There's tremendous reduction in ozone concentrations predicted by the model for this particular emission inventory. We think it may be biased on the high side, which would mean even lower emission or lower ozone impacts. Does that answer your question?
Yes, I think so. Thank you for clarifying your testimony.
All right, thank you. Member Cates?
No questions.
All right, Member Bitzer?
No questions.
Thank you. Member Garcia? No? No questions. And Member Hunker?
No questions.
Thank you very much. Did any of that raise anything for you on redirect, Mr. Rose?
No, I have no redirect questions for this witness.
All right. Thank you very much, Mr. Rose and Mr. Blewett. Let me encourage Mr. Blewett to review his settings or perhaps find another computer. I have to say, listening to technical modeling testimony is hard enough, to really follow for those of us who are not air quality modelers without the challenge of listening to the sound from a distance.
I will do my best, Madam Chairman.
Thank you so much. All right, it is 4:57. We do have a 5 o'clock public comment session. I think we should take a 5-minute stand-up break before we do that. Just 5 minutes just to stand up. Let me speak the names of those I have who've made requests to make public comment at 5. If I do not read your name and you wish to make public comment in the 5 o'clock slot, please reach out in the chat. I have Sandra Ely, Ernie Carlson, Rob Rodriguez, Mary Ingham, Dora Lucchini Lucero, Richard Raynaud, and Nick King. Let's take 5 minutes. Let's come back at 5:05, and I will. I'll begin with the names there, and then I have a question for Ms. Gutierrez. After public comment, will we be discussing the forecasted schedule, or should we address that before public comment? Ms. Katz, do you have an opinion about that?
Well, Madam Hearing Officer, Mr. Baca still needs to do his rebuttal on this topic. So I'm not sure when, did Kinder Morgan submit testimony on this or?
We did not submit testimony. I was just asking for, the next couple of days, what the schedule would look like generally.
Oh, sorry. Yes. I didn't realize that was the question.
All right. So let's come back at 5:05. We'll take some public comment. Let's come back from the break, please. Teresa, you okay? All right. I don't know about you, but I had to stand up for just a minute. All right. We have arrived at the 5 p.m. public comment session for Monday, September 20th in the rulemaking on EIB petition 2127. I will ask you to collect your thoughts as I'll be asking for your comment just once. In the event you have more to say, more than 5 minutes, I will ask you to put your comments in writing and submit them to Pamela Jones, whose contact information is on the EIB webpage. I do have to ask folks to be sworn to tell the truth, and I will, if you have a non-standard spelling of your name, I will ask you to spell your name. And let me get my little stop clock up, and I will call you in this order. Sandra Ely, Ernie Carlson, Rob Rodriguez, Mary Ingham, Dora Lucchini Lucero, Richard Reynaud, and Nick King. If you can hear me and you would like to speak in this slot rather than one of the 3 slots available every other day of the hearing, please reach out through the chat and I will add you this evening. So, Sandra Ely, I am unmuting you. Ms. Ely, would you raise your right hand, please?
Okay.
Do you swear or affirm to tell the truth?
I do.
Thank you very much. Starting your 5 minutes now.
Good afternoon, Madam Hearing Officer and members of the board. My name is Sandra Ely, and I am the Environmental Protection Division Director at the New Mexico Environment Department. Executive Order 2019-003 to address climate change and energy waste prevention sets a greenhouse gas emission reduction goal of at least 45% below 2005 levels by 2030. The order also established the Interagency Climate Change Task Force and directed the agencies to implement specific greenhouse gas emission reduction strategies. Some of these strategies have already been implemented, including passage of the Energy Transition Act by the legislature in 2019 and adoption of new energy conservation codes by the Regulation and Licensing Department in 2020. The order directed both the Environment Department and the Energy and Minerals Department to reduce methane emissions and energy waste in new and existing sources in the oil and gas industry as soon as practicable. The agencies worked together with stakeholders for a period of 2 years to draft separate yet complementary rules that do not duplicate, conflict, or leave regulatory gaps. The 2 sets of rules are designed to work together to provide full coverage of the industry to achieve the waste and pollution reductions New Mexicans deserve. While the Environment Department proposed rule focuses on NOx and VOC emission reductions as required by state law, reducing industry-wide VOCs will also result in methane reductions. The Energy and Minerals Department natural gas waste reduction rules were adopted by the Oil Conservation Commission in March of this year. It is now time for the EIB to consider and adopt regulations to help the state fight climate change and reduce ozone pollution. These rules are important for many reasons. One, because New Mexico's oil and gas industry accounts for 53% of the greenhouse gas emissions in the state, the vast majority of which is methane. We must curb emissions in this industry to meet our greenhouse gas reduction target. 2, these rules provide an opportunity for New Mexico to do its part to reduce global temperatures in the short term. While methane is an extremely potent greenhouse gas, it is short-lived in the atmosphere compared to carbon dioxide. Reducing the atmospheric concentration of methane now can slow temperature rise through mid-century. 3, these rules will serve as an example to US EPA as they move forward with regulations to reduce methane and VOC emissions in the oil and gas industry, as directed by President Biden on his first day in office. We anticipate EPA's proposed rules will be released any day now. In developing and finalizing the rules, EPA has and will continue to look to states like New Mexico to see what is possible to achieve significant emission reductions. Finally, these rules will help reduce ozone pollution in parts of the state close to or exceeding federal health-based standards. Elevated levels of ozone pollution not only put the public health at risk from breathing unhealthy air, but could result in EPA stepping in to mandate that the state implement federal requirements to reduce ozone pollution. Federal requirements will include newly imposed and extensive permitting protocols that will be costly to industry and will require the department to step up significantly. Thank you for the opportunity to provide public comment today, and thank you in advance for your efforts to ensure that these complicated and highly technical rules are protective of public health and the environment.
Thank you very much, Ms. Ely. Ernie Carlson is next on my list, but I do not see him among the attendees under either Ernie or Carlson. Commissioner Carlson, in the event that you are with us under a different name, please reach out through the chat or reach out through text to 505-660-4305. Let me move
Hearing officer, if I have a question
Mr.
with
Rose.
respect to Ms. Ely's testimony. Was that intended to be part of the department's affirmative case, since Ms. Ely in fact is a department employee? I noticed it was labeled as public comment, but it appears to be comment on behalf of the department as opposed to really public comment. And I was curious as to whether it'll be considered part of the department's case or will be public comment, given the weight the board normally does to just public comment.
All right. Ms. Katz or Mr. Knight, would you like to address that? It may have been designated as public comment because it was more policy than technical, but let's see. Ms. Katz, there you are.
I believe it was a statement by Ms. Ely, non-technical statement by Ms. Ely.
Madam Hearing Officer, there were certainly technical representations as to impacts and how this ought to be regulated. It seemed to me this is much more akin to testimony that would normally come in under the department's case in chief or rebuttal case, as opposed to public comment.
And so let's say that it would be more typically part of the department's or petitioner's affirmative case. Is it because you want to ask questions?
Well, in fact, we would normally, if this were part of the department's case, they would submit pre-filed direct and rebuttal testimony that all of the parties would have the ability to respond to, as well as then ask questions. I think a lot of what Ms. Ely covered was actually covered by Ms. Bisbee Keene in terms of her testimony that was pre-filed, but it sort of deprives us of the real ability to question it. I'm not sure I have any questions, but it's hard to decide whether to ask questions based on the fly here without having access to this pre-filed testimony.
Okay, so I disagree with you about the pre-filed testimony because it wasn't technical, and non-technical testimony, that is to say more in the nature of policy, is often not pre-filed. But as I said, you are always entitled to question anyone testifying. So if you have a question of Ms. Ely, I will ask her to rejoin us.
I do not.
Okay.
It was more a question of what weight should be given to the statement as opposed to.
All right. My understanding is that the board will be weighing all of the technical testimony and all of the non-technical testimony as part of their deliberations. All right, but thank you for speaking your concern. I'm going to move to Rob Rodriguez, but I do not see Mr. Rodriguez on the platform. Again, anyone who isn't necessarily able to join us at the exact time they said they wanted a slot for can certainly choose any one of the other 28 opportunities to offer comment. We move then to Mary Ingham. Do we see Mary Ingham? I do not. Dora Lucchini Lucero. Let me see if sorry, it just takes a minute to scroll through 160 names. So I don't see Dora. Let's see, Richard Reno. I believe I saw Richard Reno. There we go. Mr. Reno, can you hear me?
Yes, I can.
Terrific. I can hear you, but you're a little soft. If you would keep your voice up, please.
Okay.
And if you would raise your right hand first. And do you swear or affirm to tell the truth?
Yes, I do.
And would you spell your last name, please?
Yes, it's Reynaud.
All right. Your 5 minutes starts now.
Okay, I've only got about a minute and a half, but can you guys see me? Or any of you, or just my voice?
No, it's just your voice. The public comment is coming through audio, not video.
Okay, that's fine. I was just wondering, you know. Okay, all right. Hello, my name is Richard Renault. I am a lifelong Las Cruces resident, except for 3 years in Roswell, New Mexico, in oil pump development work. I graduated from NMSU in 1982 with a degree in ME. I'm retired now and am a small business owner and PE. Thank you to the New Mexico Environmental Improvement Board for allowing these hearings. Now, I have been following this rule. I've read summaries from proponents and opponents of this rule and the rule, that lengthy rule. I am not in favor of this rule. When I assess the situation, the economic impact stands out to me. The state of New Mexico's own Legislative Finance Committee expressed its concerns about future revenues, mainly affecting education in New Mexico, or largely affecting. And the small business exemption, $250,000 gross income for employees less than 10 just doesn't make any sense to me. To gross up $250,000 with 10 employees, that's a lot of work for almost no profit. Does this simply mean no exemptions? Now, unemployment. From today's Las Cruces Sun News, New Mexico was tied along with Connecticut and New Jersey for the nation's 4th highest unemployment rate. You go to page 4A and you find that Lee County, Hobbs, Lovington, has the 2nd highest unemployment rate in New Mexico. Is this the right time to do this? So in summary, I recommend to not pass this rule. Let Southeast New Mexico residents decide if they want to go beyond EPA restrictions. Where's the complaints about air quality from Hobbs, Carlsbad, Lovington? I haven't heard any. During my time in Roswell in the oil pump business, I met people in Artesia, people who are working small marginal production wells. They are hardworking, honest people making an honest living and have been painted in a bad light, in my opinion. And I will speak up for them. Thank you again to the New Mexico Environmental Improvement Board.
Thank you, Mr. Reno. All right, I see Mr. King, Nicholas King, standard spelling. I'm unmuting you, Mr. King. Can you hear me?
Yes, I can.
I can hear you very clearly. If you would raise your right hand, please. Do you swear or affirm to tell the truth?
I so affirm.
Thank you. Your 5 minutes starts now.
Well, first of all, I would like to thank all of this panel for the hard work on these life and death issues. It's no small thing to deal with all this tedious issues. And I thank you for doing that for all of us. My name is Nick King, and I'm pastor of the Carlsbad Mennonite Church. Caring for God's creation is a God-given responsibility that we are all charged with. Caring for the health of our neighbors and caring for future generations in the middle of this climate change is what we are all obligated to, unless we just serve our own immediate economic interests, which Jesus would call selfishness, one of the most basic of sins. It's self-interest versus the best for all. That's the question. In the last few years, a lot has been improved in the oil field as we see considerably fewer flaring in this area now. That's just one of the visible effects. So things can be changed. Improvements can be done, as we see in Colorado. But we need more monitoring. There's very little monitoring down here to see what the air quality is. And we need more regulation, although none of us likes regulation, but we need regulation of leakage, of pneumatic valves, and of emissions for completion and redevelopment projects. This may cost a little more or will cost a little more, but as in construction, there are all kinds of costs of doing business. The question is, do the companies for profit pay now, or do we as taxpayers and healthcare providers pay way more in the future for this upcoming fiasco? But we as taxpayers need to front the money for much more reasonable inspections, or we will all certainly pay later that there is way too little money for inspections and enforcement of that kind of stuff. I've been out in the oil field, and leaks can easily be seen with the FLIR camera. We have the technology to do this. Although we all need to do our part in consuming less, me included, and producing less carbon, we as a society need to make realistic regulations that manage the larger entities for the good of all. May God give each of you wisdom and strength to move ahead in spite of the strong opposition of some economic interests. Thank you.
Thank you, Pastor King. All right, let me ask if there's anyone else who would like to make a public comment at this session. There are 28 more sessions at 9, 1, and 5 between now and October 1st. I see no one reaching out through the chat. Ms. Katz, it seems to me like it would be worthwhile, so long as it wouldn't be too lengthy, to return to Mr. Baca. I'm sorry, Mr. Knight. To return to Mr. Baca for his rebuttal, unless you think that would be a more lengthy exercise.
We would like to do that, Madam Hearing Officer. Mr. Baca has prepared a demonstrative PowerPoint for this, and I acknowledge that we should have sent it around to the other parties. I will represent that it consists of the figures and maps that were attached to some of his written testimony. So I don't think there's anything surprising or controversial in this PowerPoint, and so I would ask that he be allowed to present that PowerPoint along with his rebuttal testimony if there is no objection. And I would say if someone, I would ask that we be allowed to present it, and if any party has an objection along the way, we can deal with it at that time.
All right, I think that's a good strategy. Did I hear someone trying to say something? No. All right, I think that's a good strategy.
Just one question. I was wondering if Mr. Knight would make sure that the rest of us get a copy of that demonstrative exhibit. Doesn't have to be this evening, can be tomorrow at some point. That would be fine.
Yes, I appreciate that. and we will certainly send that out to all the parties very soon.
All right.
Thank you, Madam
Mr.
Hearing Officer.
Rivers. Thank you, Mr. Knight. To the extent any other party believes that they have been subjected to some unreasonable surprise as we go through Mr. Baca's rebuttal, please, I'll give you an opportunity to put that on the record at the right time. In the meantime, going to make Mr. Baca a presenter.
Thank you.
Mr. Baca, you should have the privilege of sharing your PowerPoint.
Thank you, Madam Hearing Officer. I do have that privilege now.
So, Mr. Baca, let me know when you're ready for me to begin the questions for your rebuttal.
Okay, is my screen sharing at this time?
Not yet. There it is. All right. Shall we begin? Okay, Mr. Baca, now I am going to have you address issues that were raised by Mr. Mcnally and Mr. Blewett in their pre-filed rebuttal testimony. So this is rebuttal. Let's see. Mr. Mcnally's, just for everyone's information, Mr. Mcnally's rebuttal testimony was NMOGA Rebuttal Exhibit 45. And Mr. Blewett's rebuttal testimony was IPANM Rebuttal Exhibit 12, as previously pointed out. So, Mr. Baca, Mr. Mcnally contends that Chavez and Arriba County should not be included in the geographic scope of the Ozone Attainment Initiative, the Ozone Advance, and the proposed rule. Why did the department decide to include those two counties in the proposed rule? Mr. Baca, you are on mute.
I've unmuted him.
We are.
Can you hear me now?
Ah, yes, much better. Go ahead.
Okay, yes, in short, Madam Chair, members of the board, Madam Hearing Officer, in short, these counties are widely recognized as part of their respective oil and gas basins and contain oil and gas sources that emit ozone precursor pollutants and thereby cause or contribute to ozone concentrations. The statute does not require an analysis to quantify and attribute impacts from sources to determine if they cause or contribute to elevated ozone beyond any given threshold amount in any area of the state. Excuse me.
Yes, so why are some of the assertions Mr. Mcnally, or excuse me, what are some of the assertions that Mr. Mcnally makes in his pre-filed rebuttal testimony to support his position?
Yeah, Mr. Mcnally testimony is premised on the incorrect assertion that the Air Quality Control Act restricts the applicability of any regulations promulgated by the board under this provision to only those sources in counties with monitors. Therefore, he reasons that because Chavez County lacks an ozone monitor, sources in that county cannot be regulated under the board's authority provided in 74-2-5 of the Air Quality Control Act. He also assumes that the board is limited to considering only monitoring and modeling data when determining the geographic scope of regulations that promulgate under the statutory provision. He points out that the most recent ozone design value for Rio Arriba County for 2018 through 2020 is 65 parts per billion, and that does not exceed the 95% of the standard. He also claims that the department did not provide photochemical modeling results to justify including Chavez County in the proposed rule.
I see. And what does the statute say about this issue?
Yeah, the stated purpose of the regulations adopted by the board under the statute is to provide for the attainment and maintenance of the standard. To achieve this, the purpose of the statute directs the board to regulate sources within areas of the state that cause or contribute to ozone concentrations exceeding 95% of the NAAQS. The statute does not say that the regulations can only apply to counties with monitors showing concentrations exceeding 95%. So logically, the boundaries of any designated non-attainment area would not be restricted to county lines or counties with monitors.
What factors are considered in determining the boundaries for a newly designated non-attainment area?
Yeah, air quality agencies and EPA consider 5 factors when recommending and promulgating designations and non-attainment area boundaries. This includes the nearby areas that contribute.
I'm sorry, Mr. Baca, you need to slow down. You're reading and you need to slow down. It's been a long day.
Okay. Can you read back where I was at?
Yes, air quality agencies and EPA consider 5 factors.
Air quality agencies and EPA consider 5 factors when recommending and promulgating designations and non-attainment area boundaries, including the nearby areas that contribute to exceedances in violating or non-attainment areas. These factors include air quality data, emissions and emissions-related data, meteorology, geography, topography, and jurisdictional boundaries. So these are the appropriate factors for the board to consider as they provide the information to build a conceptual model of how ozone is formed and transported in a region. So although photochemical modeling data and source contribution data may be used, it has not been required for past non-attainment designations when including nearby areas in the non-attainment boundary. So source apportionment would generally be used only when evaluating non-attainment areas that span multiple jurisdictions or states.
Okay, so how would you respond to Mr. Mcnally's testimony regarding the monitor readings at the Rio Arriba air monitor and the lack of a monitor in Chavez County?
So regarding the most recent design value at the Rio Arriba monitor, they are correct in stating that the 2016 to 2018 to 2020 design value is below the standard, as we can see on the PowerPoint here. So the Rio Arriba monitor is this green line here. So we can see over the past year that fell below. So the 95% is this orange line here, and we can see that for the 2 previous averaging periods that the monitor was actually exceeding 95% of the standard.
Okay. Let's see. Well, okay.
I guess I can, let me move on to this slide here. So NMED does not operate an ozone monitor in Chavez County. However, the statute requires that the board regulate sources of emissions that cause or contribute to elevated concentrations greater than 95% of the standard. So we have 2 contiguous counties, Eddy and Lee County, that have monitoring sites with ozone concentrations above that threshold. The trend has been rising in concentrations at this site. So if we take a look, I mean, you can see that in southeastern New Mexico, that, over time, that ozone concentrations are actually rising. And this is very dramatic here. You can see in Carlsbad especially, concentrations are going up, and also in Lee County. Now, there was a drop off in the past year, but if you look from the beginning of this chart all the way to the end of the chart, there's a general direction upward. So in kind of conclusion and wrapping it all up, although county level source apportionment modeling results do not exist, the photochemical modeling conducted by Ramble clearly shows the influence of the oil and gas sector on ozone levels in New Mexico. So the proposed rule targets the control of ozone precursor emissions from that sector. Chavez and Arriba County have substantial oil and gas sector activity and are widely recognized as part of the Permian and San Juan production basins, respectively. So the emission profiles of these two counties do not differ significantly from the other counties in their respective basins. Including Chavez and Rio Arriba County acknowledges that they are part of the production bases and that the oil and gas sector contributes to regional formation. A conceptual model of ozone in the two basins would not be complete without including these two counties. Without them, the nature and cause of elevated ozone would not be fully characterized, the scope and scale of the problem would not be identified, and a complete description of nearby emission sources that contribute to the problem would not be complete. Recognizing that ozone formation and transport is not limited in geographic scope, EPA establishes non-attainment boundaries by evaluating relevant information for the entire area containing violating monitors and any adjacent counties or nearby areas that have the potential to contribute to that non-attainment violation. So using a weight of evidence to determine an area boundaries allows both states and EPA to evaluate and determine on a case-by-case basis the specific facts and circumstances unique to the area. NMED followed these principles when considering whether or not to propose the inclusion of these counties in the scope of the OAI, ozone advance, and the proposed rule.
Okay, thank you for that. And so let's talk about some of the terms here. What are air quality control regions, or AQCRs, as we call them, and why did the department choose to use county boundaries in this rule rather than AQCRs?
Right, so now I have a map up of what we call air quality control regions, just for illustration purposes. So NMED evaluated the boundaries of the state's air quality control regions. As we can see here, there's approximately eight air quality control regions in the state. And these air quality control regions share similar climate, meteorology, topography, vegetation, land use patterns, demographics, you name it. So these are areas of the state that are highly similar in more ways than just one. So EPA, as I said earlier, we have 8 air quality control regions in the state, and we have the counties in question, Chavez County in air quality control region 155, and we have Rio Arriba County split into 2 different air quality control regions. So you can see that Rio Arriba, which is this county up here, is split between AQCR 157 and AQCR 14. So the Carlsbad and Hobbs monitoring sites provide ozone data in the air quality control region that includes Chavez County. So down here, we have monitors in both Eddy and Lee and Eddy counties here that cover this air quality control region. So in the northwestern part of the state, we have 3 monitors that cover San Juan County that provides data for the air quality control region that contains Rio Arriba and the majority of the oil and gas development in that county. So we have an air quality monitor up in San Juan right here. We have one in Farmington, and we have one closer to the east. So we have 3 air quality monitors in close proximity. We also have an air quality monitor in Air Quality Control Region 157, and that is the Arriba monitoring site that's near the Coyote Ranger District in the National Forest there. In closing, we chose to use county jurisdictional lines instead of air quality control regions because county boundaries are widely recognized by everyone, and they're well-established lines that most of the oil and gas sources whom we are targeting are contained within these counties.
Thank you. And regarding some of the testimony from Mr. Blewett, I believe regarding the locations of monitors, is the department required to have an ozone monitor in Chavez County, and who approves the number and siting of monitors for an area?
No, we do not have a monitor in Chavez County. So NMED's monitoring network is fully approved by EPA. So EPA takes the reins in reviewing and approving NMED's plans for monitoring air quality. And as a matter of fact, the department actually operates more ozone monitors than is required by EPA regulations. Every year, the department undertakes an annual review of their monitoring network to evaluate the adequacy of the network and to document any changes that the department would like to make to any monitoring site. In addition, that annual review includes a statement of purposes for each monitor, and also includes evidence that the siting and operation of each monitor meets the requirements of the regulations. So all network plans are subject to public comment, and we submit these to EPA for.
So what about Mr. Mcnally's statements concerning the lack of photochemical modeling that would justify including Chavez or Rio Arriba counties? What about his statements concerning the lack of photochemical modeling?
Yeah, as I said before, technical assessments are helpful to define the magnitude or relative magnitude or contribution from nearby areas, but EPA does not set any threshold contribution level or bright line test for determining whether a contributing area should be included within the boundaries of a given non-attainment area. So Section 107D of the Clean Air Act does not require EPA to set this threshold contribution. And although that photochemical modeling results would be insightful, they are not required in just one of the many tools available to Air Quality Agency or EPA to determine an area's influence on another non-attainment area. So the statute does not require the department to provide photochemical modeling results to justify inclusion in any of the areas or county in this case within the scope of our proposed plan. And EPA's past guidance for non-attainment boundary determinations, which are the 5 factors I reviewed earlier, are considered the appropriate framework for determine which county should be included in the OAI and the proposed rule. So although the department did not complete a 5-factor analysis for each basin, the board can consider those factors and conclude that 1, the available air quality data indicates that we have elevated ozone levels in excess of 95% of the standard, and that's in and nearby both of the counties in question. As we can see by this slide, 12 of the 14 ozone monitors operated by the department are greater than 95% of the standard. 2, we can say that there's significant oil and gas activity in both of these counties and that they share similar emission profiles as either Eddy and Lee County or San Juan County in the Northwest. So with both their basins, they do not differ significantly. 3, I think we can say that the counties share climatological and meteorological conditions as demonstrated by them being within the same air quality control region within their respective basins. And, we can also say 4, that the counties are adjacent to the monitors that are exceeding this threshold. So they're in close proximity to the monitors that are reaching 95% of the standard. So additionally, any of the topography or geographical features of the areas do not allow for unrestricted airflow or transport of pollutants in the areas. So I think 5, all the areas that are considered right now are under the jurisdiction of the EIB. They're easily identifiable, and I think the board should include Chavez and Arriba County within the scope of this role. This would properly address emissions from the oil and gas sector and lower ozone concentrations across the state. I think failing to include these areas in emissions would be contrary to the intent of the statute and ignore the fact that these 2 counties are part of the common oil and gas production basin within their respective areas.
Thank you, Mr. Baca. Mr. Mcnally has concerns with the photochemical modeling section of our ozone advanced path forward, which was, again, NMED Exhibit 4 that was discussed a little earlier. Did you review his concerns with the ozone advanced path forward, and how has the department responded to those concerns?
I have reviewed Mr. Mcnally's rebuttal testimony in this regard and agree with his assessment. So in response to that, the department revised the ozone advanced path forward and have entered it as NMED exhibit number 4 amended.
Okay.
So the discussion that was included in the original path forward was not ever intended to provide any technical support or justification of the rule. It's only explanatory for EPA and the public and the department to provide information to them on the modeling study and the important sectors that are contributing to ozone formation. It also outlines how the department plans on addressing the issue. So some of the changes that I made to the path forward in NMED Exhibit 4 amended include a more complete description of the modeling, additional commentary to support the conceptual models of ozone formation in the state. I included the updated modeling and source apportionment results for the future year oil and gas control scenario as proposed in the rule. And I included a discussion of the sectors that will be addressed through the Ozone Attainment Initiative, including the impact of the oil and gas sector throughout the state, as well as other sectors that impact ozone levels in the state and that the department intends to target for control strategies and future rulemakings.
Thank you. And Madam Hearing Officer, we have made the amended Exhibit 4. We have sent that to all of the other parties, and after they've had a chance to look at it, maybe I can renew my motion to have that admitted into the record. Perhaps we can do that tomorrow morning after everyone's had a chance to review it.
Yes.
And now we have rebuttal to Mr. Blewett's rebuttal testimony.
Please go ahead.
And Mr. Baca, thank you. Mr. Baca, IPA&M witness, Mr. Blewett, who testified earlier today, in his written rebuttal testimony, he suggests that the department should follow sections 110 and 172 of the Clean Air Act to develop the plan to address ozone as required by the Air Quality Control Act. Do you agree?
No, I don't. Mr. Blewett is trying to apply a state implementation plan and permitting concepts and frameworks both to the board's duties to act under the Air Quality Control Act. So these concepts and frameworks use terms such as cause, contribute, and significant, but there's no context with what he was providing these terms in his rebuttal testimony. So the concepts he describes and frameworks he suggests are inappropriate for determining the boundaries for this purpose, for the OEI, the Ozone Advance, and for the proposed rules. What he's suggesting would be used to comply with requirements of the Clean Air Act, not the New Mexico Air Quality Control Act. So when I say that, I'm talking about, he brought up Section 110A of the Clean Air Act, which requires states to develop SIPs for the implementation, maintenance, and enforcement of new or revised standards. So these SIPs are commonly referred to as infrastructure SIPs or ISIPs because they ensure that the basic authorities and programs are in place to implement any new or revised NACs that the EPA may put promulgate. The department has submitted its ISIP to EPA under Section 110 for the 2015 ozone NACs in 2 separate submissions. So EPA has fully approved New Mexico's first ISIP submission that addressed all but one of the required elements under Section 110. The second submission, this board just considered this past summer, and that was for the interstate transport of ozone, or what we commonly refer to as a good neighborship. And this was adopted by the board and submitted to EPA, I believe in July of this year. So that was just recently done. And EPA is required to act on that submission on or before January 4th, 2022. So in short, the plan described by Mr. Blewett already exists for the state of New Mexico, and it is not intended to encourage any of the early and proactive measures to reduce emissions before a non-attainment designation, only to ensure that the department has the capability of implementing, maintaining, and enforcing the standard. Section 172, on the other hand, outlines the planning requirements for ozone non-attainment areas. So the department also completed a SIP submission under Section 172, but only for the Sunland Park non-attainment area. So that this was submitted in 3 submissions to EPA this past summer. And it's of note that the Sunland Park area is the only designated ozone non-attainment area in the state. And I believe, in my opinion, that it's the only one where Section 172 requirements apply. The OEI uses EPA's established framework for the Ozone Advance program to develop their moving forward. The program is a successor of the early action compacts that EPA was engaged in which NMED participated in the early 2000s in the San Juan Basin, as we started addressing rising concentrations in that area. So the department feels that the intent of the statute closely aligns with the principles, practices, and goals of the advanced program and continued down that path.
Now, Mr. Blewett concludes in his rebuttal that the statute requires a plan in Doña Ana County only, since future year modeling shows compliance with the ozone NACs in all other areas of the state. Is that your understanding of the statute?
No. Modeling is not a required component to demonstrate cause or contribute in this context of boundary determinations. Additionally, the requirement for a plan is triggered when the ozone concentration is in excess of 95% of the standard, and could be reasonably attributed to sources within the board's jurisdiction, including the oil and gas sector, and any other sectors they determine to cause elevated ozone concentrations.
Okay, thank you, Mr. Baca. Madam Hearing Officer, those are all the questions that I have for this witness, and he is available for questions from anyone else.
All right, thank you very much. I think there are so many of us. I will put the presentation screen away. There you go. Thank you. Ms. Fox, do you have questions of Mr. Baca based on his rebuttal testimony?
No, thank you, Madam Hearing Officer. Mr. Baca, thank you for your testimony today.
Thank you. Ms. Paranos?
No questions.
Right.
Thank you.
Professor Pasiniak? I think that was a no. Ms. DeVore?
We have no questions.
All right. I think that was Mr. Vimont speaking.
Yes, it was, sorry.
Okay, all right. Let's see here. Mr. Nykiel?
No questions, thank you.
Thank you. Mr. DeSalen?
No questions, thank you.
Thank you. Mr. Heiser?
Madam Hearing Officer, this is Eric Heiser for Nemoga. We are going to have multiple questions for Mr. Vaca on this. And I must say that we're a little bit surprised to find that there's revisions to Exhibit 4 that we need to evaluate specifically in response to the comments from our witness, Dennis Mcnally. As is known to the department, Mr. Mcnally was in surgery today and hence is in no position at this point to review or provide any thoughts on the document that are revisions ostensibly and changed is. So I would like to be able to not have to take up that exhibit right now because I don't have my expert that they're responding to provide me any thoughts on that.
All right. So we can certainly take up the question of the admissibility of the exhibit on another day. It seems like we're going to be together for a long time. But do you have questions of Mr. Vaca?
I do have questions of Mr. Vaca, and I don't know that I can do my questions about his exhibit because we haven't had an opportunity to review it. So if I can reserve my questions on the changes to the exhibit until sometime in the future, I'd appreciate it. But I do have questions on his other testimony otherwise.
All right, go ahead.
Mr. Vaca, in the development of the plan and of this rule, has not the department itself stated that it's relying upon the design value?
Relying on the design value, can you expand on that? To rely on the design value for what?
To designate the areas of the state that are subject to the scope of this rule?
We are using monitoring data as one of the factors to consider the boundaries of the rule, the scope of the rule, and the Ozone Attainment Initiative.
So is it not true that in section 20.2.50.2 of the department's proposal that you specifically reference design value as the criterion that's being used? Yes or no?
Yes.
Now, in the filings that you did, you talked about the statute that the legislature passed that is authorizing this action. Is that correct?
Yes.
And in that, you talked about the cause and contribute. But if we look at that statutory provision, does the cause and contribute finding go to the areas that are subject to regulation, or does it go to the types of sources that are subject to regulation under this program?
Now, it says that emission sources within the Environmental Improvement Board's jurisdiction.
Right.
Cause or contribute.
Right. So in order for you to regulate a source, is it the department's duty to show that they cause or contribute to ozone concentrations in excess of 95% of the standard?
I do not believe so. I just believe that we have to show that there's a 95%, an exceedance of 95% of the standard at the monitoring site.
So is it your testimony that the department's belief is that as long as some area of the state is in excess of 95%, you may regulate any source of any type?
If we have reason to believe that it's causing the impact, yes, we can.
So you do believe that you have to show a cause or contribute in order to regulate under this program?
No, I don't. We can. I mean, it's part of the tools that you can use, but it's not the only tool. So we do have many other tools to show that emission sources or the magnitude of emissions could reasonably impact adjacent area, let's say, or any other area in the state, for that matter.
So what then does the first sentence of section C of the statute direct the department to do?
The first sentence, it doesn't direct the department to do anything. It directs the board to it determines that the emission sources that they have to adopt a plan.
I accept your correction that it doesn't direct the department, but the department is recommending to the board, is it not, that the board do something, correct?
Correct.
Okay, and what are you recommending to the board that it do under this first sentence of subsection C?
So what we are planning to do is outlined in the Ozone Attainment Initiative. That has not changed from the initial Exhibit 4. The purpose of the Ozone Attainment Initiative and Ozone Advance is to take proactive steps to avoid a non-attainment area designation.
So how do you know which sources to regulate under the Ozone Attainment Initiative or Ozone Advance?
Well, you would evaluate which sources are in the area in the emissions as we've provided in Exhibit 4 that are part, what is being emitted. And I think I went over the 5 factors that we considered. And the 5 factors would be what we considered for including or determining which areas cause or contribute to exceedances of 95% of the standard.
Okay, but does the statute speak to areas that cause or contribute, or does it speak about sources that cause or contribute?
Sources.
Yeah, so not areas. With respect to areas, what does the last sentence of subsection C of the statute speak to? I can quote for you. It says, rules adopted pursuant to this subsection shall be limited to sources of emissions within the area of the state where the ozone concentrations exceed 95% of the primary national ambient air quality standard. Does that establish a geographic limit to the area which regulations may be applied to sources?
No, it does not. It just says it's limited to sources with emissions within any area of the state where ozone concentrations exceed. So it could be any emissions anywhere in the state that within the area of the state that ozone concentrations exceed 95%.
So is it your testimony that the first sentence of subsection C has no bearing on the last sentence of subsection C?
No.
Then how do you reconcile the first and last sentences of subsection C? How do they fit together in your view?
So the rules are limited to the sources within the department's jurisdiction that can, within areas of the state where ozone concentrations are monitored at 95%. So the rules can apply to any part of this, any area of the state where monitoring can reasonably be attributed at exceeding 95% of the standard.
Okay.
So it would be an air quality control region, would definitely be the first area you would look at, would be the air quality control region.
But right now the department's chosen to do counties for the moment.
Right, and in my rebuttal, I said that we started evaluating from the air quality control region level to come down.
Okay. Now, in the testimony, you talked about the 5-factor analysis for cause and contribute, I believe. That comes from the federal program, is that true? Those 5 factors?
Right, this is not for cause and contribute. These 5 factors come from EPA guidance on when they designate non-attainment areas. So when EPA considers what nearby areas are causing exceedances of 95% of the standard, they will undertake these 5 factors and not necessarily include one in their determinations.
And is the department's analysis of those 5 factors set forth in any place in its materials prior to your explanation today in your rebuttal?
No. This is, I believe, a policy decision that was not technical testimony within the Ozone Advanced program, and so we did not include it. We determined the appropriate method to develop the plan, in other words.
Now there was a question where you responded to Mr. Blewett's interpretation of plan, and you said that you didn't agree with that, correct?
Correct.
Did you provide any citation to authority for what you suggested, or is that your interpretation of what plan means to you?
Can you restate that? Can you clarify that?
In other words, when you gave your response to Mr. Blewett, were you relying upon a department policy or a regulation or a state statute or a guidance manual that you developed within the department that sets forth the view of what a plan is? Or were you giving your feel for what it is based on your position in the planning unit?
The Air Quality Control Act just states plan. That's all it states. It doesn't say state implementation plan. It just says plan.
And what does plan mean to you as an air quality professional in the regulatory field?
A plan?
Yes.
Well, it could mean anything. It could mean education and outreach. It could mean any control strategy that you're taking to improve air quality.
Okay. Madam Hearing Officer, that's all I have for him right now. Thank you.
Thank you very much, Mr. Heiser. Mr. Rose, do you have questions of Mr. Baca?
Yes, Madam Hearing Officer, just a couple of questions, I hope. Mr. Baca, when you discussed the ozone levels potentially in Rio Arriba County, you indicated that there was a monitored location, I believe, somewhere in the middle of the county. Could you explain where that is and who maintains that monitor?
Yes, that is the Coyote Ranger District in Rio Arriba County, and that is maintained by the New Mexico Environment Department.
And are there other monitors in Rio Arriba, or is that the only one?
That's the only monitor.
Okay. Thank you, Madam Hearing Officer. I have no further questions.
Thank you, Mr. Rose. Mr. Jano?
No questions, Madam Hearing Officer.
Thank you. Mr. Boutier?
No questions.
Thank you. Ms. Gutierrez?
No questions, thank you.
Thank you. Mr. Newman?
No questions, thank you.
Thank you. And Ms. Witherspoon? She may have stepped away. All right. I'm going to turn now to the board members to see if they have any questions of Mr. Baca. While I'm doing that, if you are not a panelist and you have a question of Mr. Baca, please reach out to me in the chat. Madam Chair, do you have questions of Mr. Baca?
Madam Hearing Officer, I don't have any questions at this time.
Thank you. Vice Chair Trujillo Davis.
I do not have any questions at this time. Thank you.
Thank you. Member Cates.
No questions. Thank you for asking.
Okay. Thank you. Member Bitzer.
I'll be a real simple, real quick question. My municipal level government work is really dated, but is there a difference between an AQMD and the AQCR? The old air quality management district that I dealt with in Bernalillo County. Is that different than the AQCRs that you are talking about now?
Member Bitzer, Madam Chair, and Madam Hearing Officer, yes, that is. An air quality management district generally refers to a local air quality control agency, such as the Albuquerque Bernalillo, but that term is much more applied in California, where they have a lot of local air quality jurisdictions, which they call air quality management districts.
We had one as Bernalillo County back in, we probably still do.
We still do.
But, yeah, once you're under those, it's hard to get out. So, thank you. That's all I had.
Great. Thank you, Member Bitzer. Member Garcia.
Yes, Madam Hearing Officer, I have one quick question. Mr. Baca, you mentioned that there's no monitor in Chavez County. Could you tell me, does the department have a plan to put a ozone monitor in Chavez County?
I do not believe so at this time. As I mentioned in my testimony, the requirements for ozone monitoring are far exceeded in that area of the state. We have more than required monitors throughout the state.
Thank you, sir. That's all.
Member Hunker.
No question.
All right, thank you very much. Mr. Knight, did that line of questioning earlier raise any need to do redirect for you?
Yes, Madam Hearing Officer. I think I maybe just one or two redirect questions, if I may. Mr. Baca, now, is it true that Chavez County is in the same air quality control region that the Carlsbad air monitor is in?
Yes, it is. It's within the same control region as the Carlsbad and Hobbs monitor.
And is it true that Rio Arriba County is, or at least a portion of Rio Arriba County, or half of it is in the air quality control region, the same air quality control region as San Juan County?
That is correct. The 3 monitors in San Juan County are within the same air quality control region as the oil and gas sources in Rio Arriba County. So if you remember, the Rio Arriba County at the Continental Divide is split east and west, and on the west side of the Continental Divide is heavy oil and gas activity right along the San Juan border, and really close to our Navajo Lake San Juan monitor.
Okay, thank you. That's all the questions I have for this witness.
All right, thank you. Is there any reason not to excuse Mr. Baca? No? Thank you very much, Mr. Baca. As I understand it, other parties may or may not have questions once they've had a chance to look at amended Exhibit 4. But so far as I know, that would be the only reason to recall them based on the events of the last hour. So thank you, Mr. Knight, for that. 2 things. We should adjourn for the day, I believe. But two things. One is a request from the board of all parties, which is when you call your witness, if you would please, as part of your calling that witness, or in the earliest remarks of that witness, identify the exhibits that represent their testimony and the other exhibits they'll be talking about. It helps those of us who are surrounded by boxes and scrolling through thousands of pages of documents on the screen. So please do that. The other thing is, Ms. Katz, if you would please address the topics we're going to be able to cover tomorrow. We have just a little bit of public comment, so far as I can tell right now, at 9. And then, as I understand it, we're going to be leaping into modeling.
Yes, Madam Hearing Officer, that's the plan is, and I believe all the parties, I haven't heard any issues with that. I believe all the modeling witnesses are available tomorrow except for EDF's witness, and perhaps she can be, she can put on her testimony on Wednesday at some point. And so yes, I think modeling, the economic analysis and the small business facility definitions at topics 5 and 6 need to go on Wednesday and hopefully first thing in the morning because of our the department's witness who is in the UK. So I think what I would propose would be we do the modeling and then we maybe move it down into some of the topics on 8, 9, 10, and some of those, and see what we get through.
Thank you for that, Ms. Katz. Mr. Heiser, I see you on screen. Do you have a comment?
Thank you, Madam Hearing Officer. I just had a question, actually 2 questions for you. The first is, the order is a little bit unclear, but is it your intent that we circulate rebuttal materials in advance as well? Or not? We just need to know for purpose of timing and planning.
Yeah, I think it would, things would go more smoothly if you could do that.
Okay.
Any comment on that, Ms. Katz?
Yes, ideally, yes, ideally that would be better than not if they're prepared.
I think that we certainly understand that there may be times that parties run into problems. I just was trying to understand the expectation of us as well, so that we knew when we needed to have things available. And then the second question, somewhat related to that, Madam Hearing Officer, is that Mr. Rose was a bit flustered, as were you, during the discussion with his witness Blewett. And I don't know if we actually touched on all the exhibits that were related to Mr. Blewett's testimony for today. And so I just wanted to make sure that we had appropriately put the record together for that.
Yeah, so we can clear that up tomorrow. Looking at the wrong, when he pulled up the wrong slide deck, it was confusing, and I wasn't sure why I was confused. But let's
That would be
let's clear that up when we next see Mr. Blewett. And I'll try to make a note of all these loose ends.
Thank you.
Is there anything else that we can discuss while we're together this evening before we adjourn? Otherwise, we'll see you at 9 o'clock tomorrow morning. Again, I don't have a lot of public commenters at this moment, and then we'll leap into the modeling and go from there. Thank you all. Have a good evening.
Thank you.